Please welcome attorney Jeff Bodyke, A Decade of Unchange.
So I was trying to think about how I wanted to start this morning, whether I wanted to tell you this story up front or at the back, and I want to tell you up front. So I'm a criminal defense lawyer, and I make most of my living and always have in the appellate courts, which means that my clients have almost all already been convicted of something, and often of very terrible things. I do a lot of death penalty work, and mostly, not always by any means, but mostly people who are convicted of crimes in this country have done something kind of within taxi cab distance of what they're convicted of. Maybe not exactly what they were, maybe not even what they were charged with, but somewhere in the range of what they were convicted. Yeah, mostly they've done something like that. And so I represent a guy, and I have for now going on 7 years, and probably will for another 6 or 7 years. I represent a guy in Ohio who is on death row for the rapes and murders of 11 women, and he has 11 death sentences. And when I've been in court arguing for him, I'm making legal arguments and trying to say, look, here's what you want to do for this guy, and here's why you should. Because when we're doing what they teach you in law school, is this is the way the law works. That some high court sets a rule, and your job as a lawyer is to convince courts that your facts are just like the facts, or close enough to the facts in the case where the high court set the rule, so that it's going to follow, so that the court you're in front of, the judge you're in front of, is going to follow that rule, and you're going to win your case. So, and the other side has another case and another rule, and so what you have is, okay, Your Honor, my case is just like the case of Humpty, and so I win. And then the other side gets up, the prosecutor gets up and says, it's nothing like Humpty. This case is just like Dumpty. And then you've got some judge who says, I will carefully analyze the facts of this case and analyze the law and decide whether this case is more like Humpty or more like Dumpty, and whichever one I decide, that's the right answer, and it'll at least be reasonable and fair because I'm reasonable and fair, and I never... That's not how it works. That's what they teach you in law school, but it's not true. Here's how it works. The judges they pretty much always want to do the right thing. The problem is their sense of what the right thing is and my sense of what the right thing is often don't go anywhere near each other. So my job as an advocate, as a lawyer, and frankly as an advocate in any context, is to get people to see that what I want them to do is the right thing, and then give them an excuse. In my case, because I'm a lawyer in court, give them a legal excuse to do what I want them to do. I don't care whether my case is closer to Humpty or to Dumpty. It doesn't matter. What matters is the judge wants to decide my way, and then he'll decide whether or not it's closer to Humpty or to Dumpty. That's the legal excuse to do what the judge wants. So I represent this guy with 11 death sentences. He's the most prolific serial killer in Ohio history. And so far, I have to add, don't be deceived. I've been representing this guy for 7 years because we haven't won. And if we'd won, I'd be done. And mostly what I'm trying to do is get him, the goal here is to get him off death row. He's not going to go back into the streets. He's not going to have an opportunity to do this again. He's going to spend the rest of his life in prison. He knows that. I don't want him to be executed. He doesn't want to be executed. And that's what we're trying to do. Here's the interesting fact about his case. Now, the way it works is after he's found guilty, a jury has to decide whether or not, I'm oversimplifying the law a lot, but it's the only way to do this. After he's found guilty, the jury has to decide whether the horrible things he's done outweigh everything else about him and everything else you can throw at the wall, because if they do, then they're supposed to sentence him to die. And if they don't, he's supposed to get a life sentence. And the jury said they do. And here's what the jury didn't get to hear, because the judge who was the judge of the case wouldn't let them be told. And which is that of the families of the 11 women he was found guilty of raping and murdering, 9 of those families had signed a letter to the prosecutor saying, take the death penalty off the table, please. We don't want this man executed. And he would have been absolutely willing to plead guilty, waive all his post-trial rights, and spend the rest of his life in prison if the prosecutor had been willing to do that. The prosecutor wasn't, which is why we end up where we are today. And when I was in the Ohio Supreme Court arguing for this guy, much of what I said, not all of what I said, but some of what I talked about was, hey, guys, gals, judges, I didn't call them guys and gals. I said, listen, he had a right to tell them that these folks didn't want him to be killed. There's no question, that's true. It's settled. No question about it. They wrote a letter. We've got the letter. It went to the prosecutor. The prosecutor said, go away. And he would have been willing to take the deal, and that's part of the record. Everybody knows those things are true. Everybody knew that except the jurors who said, this guy ought to die. And that's wrong. The jurors should have been able to consider his willingness to accept responsibility. They could believe it or not. They could think he's just trying to save his life. He doesn't have any interest in accepting responsibility. Well, that's their call, but they should have had the opportunity to hear it. They should have had the opportunity to know that the victims' families were actually on his side on that issue, at least, if only on that issue. And in fact, only on that issue. I mean, they were not happy, obviously, about what he'd done. A very fine lawyer once told me, this was a few decades ago, told me what I kind of knew, but I liked the way he explained it. He said, they always want, and it's what I said before, judges want to do the right thing. Your job is to make them think that the right thing they want to do is what you want them to do. And that's true when we're advocating to judges, to newspaper reporters, to anybody out there. And that's why when you watch those film clips yesterday that David put up, it was the one with the story that you all said, and rightly, that's the more powerful one. The data is useful, the data is necessary, but the data doesn't do anything unless people are willing, because people aren't going to pay attention to it, frankly, unless they're first gripped by something, unless there's something that makes them, that seems to generate some sympathy. And the sympathy for my client that I'm talking about here was not, it can be the client, but it wasn't in this case him. Nobody was going to be sympathetic to him. He raped and murdered 11 women over a period of 2.5 years. The most prolific serial killer in Ohio history. No, nobody was sympathetic to him, except his lawyers. But the families of the victims, they could generate some sympathy, if only they were allowed to be heard. In 1996 or 97, Ohio adopted Megan's Law. And it was made retroactive so that everybody in prison at the time for a specified sexual offense would be reclassified as either a sexually oriented offender, a person who had committed one of the statutory lists of sexual offenses, as a sexually oriented offender, an habitual sexual offender, a person who'd done it once and who'd been convicted of a sexually oriented offense previously and now again. And in those days, plain sexually oriented offender had to register once a year for 10 years, and an habitual sexual offender once every 180 days for 15 years, or a sexual predator, and a sexual predator had to register every 90 days for the rest of their life. And the definition of a sexual predator was somebody who had done it before and who a judge determined by clear and convincing evidence, which is a pretty high standard, although it doesn't actually mean anything in the real world. It means, I believe it enough, was likely to do it again. And that was made retroactive, and all kinds of people were reclassified. And we went to court. People all over the state of Ohio went into court and said, you can't do this, you can't go back and reclassify us, that's extra punishment, and you can't punish us a second, you can't increase our punishment. The Constitution doesn't allow it. You can't increase our punishment after we've already been sentenced and from what it was. And the court said, blah. Not so. Finally, the court said. So we won some cases in the lower courts, we lost some. The Ohio Supreme Court said in 1998, no, that's no problem, because Megan's Law isn't punishment after all. All that registration, all those things, no. That's just remedial, it's just protecting the public, that's all anybody cares about. And so, yeah, you can go back and do that. And they amended Megan's Law to make it worse in 2003. Actually, they amended it a few times. But in 2003, they made it worse. And we went back to court and thought, well, okay, now it's worse. So now we can show its punishment. And again, cases started percolating up around the state. And the Ohio Supreme Court, we actually thought we were going to win this one in the Ohio Supreme Court. And we didn't. Then one of the justices was running for Chief Justice, and she flipped her vote. And so instead of winning 4-3, we lost 4-3. And then they enacted the Adam Walsh Act. And Ohio was the third state to enact the Adam Walsh Act. And it was enacted not because, frankly, anybody in the legislature thought it was a good idea. It was enacted because Congress had said, if you enact it, if you enact a version of the Adam Walsh Act, then some additional criminal justice money that we might appropriate in the future, you will get a share of. And if you don't enact it, if we ever do appropriate that additional money, you won't get it. And so with complete ambiguity about whether there was any benefit here, but gee, there's a possibility that down the road Ohio will get some extra criminal justice money from Congress, we became the third state to enact the Adam Walsh Act. And if Megan's Law, and we made it retroactive so that everybody who was classified under Megan's Law was suddenly reclassified under the Adam Walsh Act, that was 26,000 people. And the structural difference, aside from greater classification, greater registration responsibilities and requirements, and more onerous requirements and more onerous public notification requirements, the structural difference in the design of the law was that while Megan's Law did a terrible job of saying, you're a particular threat, so you will have a greater registration requirement, right? That for lifetime, a judge actually had to find that you were likely to do it again. For the 15-year requirement, which went up, of course, over time, but for the habitual sexual offender requirement, they had, well, you've done it before, and now you've done it, and that just kind of makes sense that maybe you'd be more likely to do it a third time. Adam Walsh Act doesn't care about any of that. It's a low-level offense, but you're absolutely certain to keep doing it forever, that's okay. You're the bottom of the registration requirement. A massive, you viciously rape people, but you have, as a consequence of what happened afterwards, you're now a quadriplegic who has to breathe only through an oxygen, and there's no chance in the world you'll never have the opportunity to commit. You have a lifetime registration requirement, even though you're not dangerous to anybody, and we all know that. It's a stupid plan. I mean, assuming you believe that the registration and notification requirements have some sense at all, have some rational basis, saying, oh, we're going to stop considering whether there's any reason to do it in your case and only look to what you did, makes no sense. It's just stupid. But that was the law, and it was enacted. Ohio jumped on the bandwagon, third state to do it. And we'd done all that work in Megan's Law and amendments to Megan's Law. Individual lawyers and organizations were working on those cases, but they were all, and at some point we'd file amicus briefs in each other's cases, but there was no overarching plan. This time we said there needs to be an overarching plan. So the ACLU of Ohio, at the time I was the legal director, and at the time the Adam Walsh Act came in, the ACLU of Ohio and the Cuyahoga County, that's Cleveland, Public Defender's Office, and the Ohio Public Defender, the State Public Defender's Office, and the Ohio Justice and Policy Center down in Cincinnati, we got together as a coalition. How can we take down some part of this law, some piece of it? More than one piece, the whole thing ideally. And we knew that what we'd done before obviously hadn't worked. We hadn't actually accomplished very much in restraining Megan's Law. So we looked around, and what we looked at, well, we looked at a whole bunch of stuff, but one of the things we looked at was the history of Brown versus Board of Education. The case where the US Supreme Court said finally, separate but equal in schools is no good. You can't have legally segregated schools, public schools. And how was that done? And the way that was done was by building a series of smaller cases, making smaller arguments, and making the smaller arguments and then putting them together, packaging them up, cherry-picking the best cases, the ones that were least problematic, or that would seem least problematic to the justices of the US Supreme Court, and making sure that you had good lawyers who were part of the planning, part of the organization, being the ones to take those cases and move them up. And we said, okay, that's a good model for what we can do. We ended up filing bunches of lawsuits. We filed a lawsuit before the law ever took effect in the Ohio Supreme. We took a case to the Ohio Supreme Court. We said, guys, why don't you just resolve this retroactivity provision? Now you got 26,000 cases that are going to start bubbling up here, and you don't want to dissolve. You don't want the courts of this state to have to mess with 26,000 individual cases. Just declare it all unconstitutional now. And the Attorney General said, oh, those 26,000 people won't be interested in doing anything. They won't care about making their lives vastly worse. So don't bother, don't do it now. And the Supreme Court said, okay, we won't do it now. And we went into federal court and we sued then Attorney General Mark Dan, who spoke yesterday, and all 88 county sheriffs in Ohio and county prosecutors, and which was kind of entertaining, but accomplished nothing, except it gave us some more time to figure out how we wanted to keep the strategy going. And then we started, as an organization, looking for cases. And we all took individual cases, and the question was whose case, and sometimes we won and sometimes we lost, cases from all around the state, and the question was the only issue really was, they had a few different issues. There were cases involving juveniles, there were cases involving adults, these were all cases involving the reclassification system and how it was going and how it would be implemented. And what we were trying to do, frankly, because there were lawyers all over the state filing these cases, and I got to tell you, a lot of those lawyers weren't doing a particularly good job, and they weren't the people that you would want standing up in front of the Ohio Supreme Court with your issues on the line. And so we were trying to cherry pick and pick off the cases that would go to the Supreme Court, and it happens that that they agreed to hear Christian Bodyke's case, which became State versus Bodyke, and it happens largely coincidentally that I was lead counsel in Bodyke, and all the lawyers from these other organizations were filing amicus briefs, and so when we were putting the arguments together to go, not the ones that we'd made along the way in the lower courts, there we just raised issues, but when we were actually packaging up Christian Bodyke's case for presenting formally to the Supreme Court, once they'd agreed to hear it, this is going to be the case, the lead case that's going to decide this stuff. They actually set 3 cases for Sex Offender Day in the Ohio Supreme Court. They set 3 cases for oral argument on the same day in 2009. And we, as a coalition, were provided the lawyers were working. All 3 of those were our cases. What we said was, okay, we had 2 questions. What arguments do we have a good chance of winning? We raised bunches of arguments, but what arguments do we have a good chance of winning, and how do we go about winning them? And what we realized was we're not going to win an argument, not in the first instance, that that the new law is punishment and therefore can't be applied retroactively. We're just not going to win that argument right off the bat. The U.S. Supreme Court says, no, that's not so. None of these laws are punishment, which is nonsense, but that's what they've said. The Ohio Supreme Court is not prepared to buck that decision right now, although we made the argument. What the Ohio Supreme Court might pay attention to is their own power. Ooh, we like that. Judges like to think judges are important. And what the Adam Walsh Act said was reclassification is done by the Attorney General. So wait a minute, you're classified by a judge and the Attorney General gets to decide whether it has to change and how? That doesn't sound right. It certainly doesn't sound right to judges. And that was, in fact, and when it was time to stand up and argue the case in the Ohio Supreme Court, that's what I stood up and started to argue. And the judges were stunned because they thought what I was going to say was, this is unconstitutionally retroactive. We'd written that in the briefs, but we were going to lose that argument. I didn't want to talk about that. The folks on the other side from the Attorney General's office were quite sure that I was going to stand up and say this is unconstitutionally retroactive. That's what they were prepared to respond to. Well, that's great. I mean, if I'm the only one who wants to talk about this, everybody else thinks I'm going to be doing something else. They're not prepared. That's cool. I'm happy to have them not be prepared. I'd always rather have them the other guys not be prepared. But we did something else. We did something else. We said, look, this is the ACLU, the Ohio Public Defender, the Cuyahoga County Public Defender, the Justice and Policy Center. Nobody likes you guys. Nobody likes us. We represent terrible people. We want to let people out of prison. No, 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 no. We represent people like our clients. Well, yeah, that's what we do. So we went and we got some other organizations to sign on to say, you know what? These laws stink. We had the Ohio Coalition Against Sexual Assault, the Jacob Wetterling Resource Center, Detective Robert Schilling, the California Coalition Against Sexual Assault, the Texas Association Against Sexual Assault, the National Alliance to End Sexual Violence. And then we got them to sign off. I mean, those aren't the usual suspects on our side in these kinds of cases. At least they don't sound like it. We got them to sign off on a brief, a friend of the court brief, that was written by a young, signed anyway, by a young lawyer, more or less fresh out of law school, working for Jones Day, which is the largest law firm in the world. It happens to be based in Cleveland. It is the largest law firm in the world. They're conservative. These are the guys who represent, these are the folks who represent big business and represent government. And they don't represent, they represent the kinds of people who hate my kind of people. and oppress my kind of people. And you know, if they're on our side, well, that's something. And then we said, okay, so we're going to have this young lawyer stand up in court and take 5 minutes of my time. We don't care if she's going to do a good job. And we'd like it if she does a good job. We don't care. What we like about this is that she's a young woman lawyer from the largest law firm in the world, based here in Ohio, and she's going to stand up and say, on behalf of these organizations who hate our clients, you shouldn't do this to our clients. We won that case. We won a few cases afterwards dealing with retroactivity provisions, dealing with increasing, at least to some extent, the opportunities for some juveniles to get to have some reclassification possibilities. I don't have any idea whether having that young woman stand up in court won the case for us. I don't know. I don't know whether having... I'm sorry, one more. Well, what year was, I'm sorry, what year, the argument was on November 4th, 2009. The decision came out in, I think, June 2010, maybe. State versus Bodyke. Well, wait a minute, no, I have the answer here. June 3rd, 2010 was the decision. And I don't know if what that young woman did made a difference. There's no way to know that. Certainly the Supreme Court's opinion did not say, and because of the wonderful work of that young woman, no, that's not what they do. They said all these other arguments that Gamso made are stupid, and and he's not going to win any of those. But yeah, he's right. The power of the courts trumps the power, because we're the courts, power of the courts trumps the power of the Attorney General to undo what the courts did. I suspect, I've always suspected, that having that young woman stand up and having her stand up on behalf of organizations who hated our client and say our client should win made a difference. Did it? I don't know. but it gave them, and we talked, the briefs were filled with the data on recidivism, which we all know. They were filled with the absurdity of going from a risk-based system, even though it was a terrible risk-based system that didn't work particularly well. At least that was the idea behind it, from going from a risk-based system to an offense-based system. We talked about all that in the briefs because we wanted to sell them on the fundamental idea that there's something you want to do. And here's a mechanism for doing it. And by the way, here are 6, half, 8, I don't know how many arguments we made. Here are all these ways you can do it. But we want you, pick one. Pick one. And we think, and it's the one I chose, that we decided I was going to argue. I make it sound, I didn't. This wasn't a unilateral decision. None of this was. This was collective work. But the decision was the one we're going to push, because the one we think we have the best chance of convincing them to do something with is, and that's the real way legal stuff works. You make them want to do what you want, and then you give them a hook to do it. And so we won a bunch of retroactivity cases, and the law of unintended consequences is that we actually ended up hurting a few people, because there were some people who actually had, because of the particular offense they had, it's a small number of the 26,000, but it was, but not to the individuals involved, because their risk had been determined to be low. They only had a lower registration, or because their offense was relatively minor, they had a lower registration requirement under Adam Walsh, and they, in fact, went back to a higher registration requirement because they'd been found to be likely to do it again. It was a small number of people, but yes, a small number of people, in fact, got hurt, which we felt terrible about, but we never did figure out exactly how to undo that, although we worked on that too. But a vastly larger number of people, thousands of people, were again reclassified to lesser terms and to, as it turns out, lesser punishments for violating those terms if they did that under Megan's law than under the Adam Walsh Act. And the Attorney General at that point actually worked with us to get people reclassified, and when that got screwed up, we would call the Attorney General's office, and they would, in fact, do fix the reclassification and go back, put people back where they belong. And we made a lot of progress. And we won some other small issues along the way. And kind of then it petered out. And from time to time, some of us will get together and say, what happened? And I mean, the easy answer is, well, we went and we had all this energy and we all worked together, and I'm no longer at the ACLU, and the person, Margie Slagle, who was the lead person from the Ohio Justice and Policy Center working on it, is no longer at the Ohio Justice and Policy Center. And so the organizations that were working hard, but the truth is the energy dissipated. And we'd won this big thing, and it was a big thing, made a difference to somewhere, probably 25,000 out of 26,000 people, and has made a continuing difference to other people along the way. And nobody knew what to do next. It was easy to see, looking back on it, what happened. Nobody had a particularly clear idea of where to go next and how to go about it next. And you watched a legislative hearing the other morning, or a mock legislative hearing the other morning, and you heard Mike Skindle explain, giving himself a little more credit than he probably deserves for this, and suggesting that he was a little more successful than he actually was. He said, but what he said basically was, we've been able to put our finger in the dike a little bit. As they've made the law worse, they haven't made it as much worse as they might have without our kind of blocking it. Well, yeah, that's basically true. And that's for the most part what we've achieved here in Ohio since then. With a few odd legal victories here and there, and a little bit of this and a little bit of that, what we've done is we've stopped them from, is some of the worst ideas they've had have not come to fruition. But many of the really bad ideas they had did come to fruition. And so it's not like we're making things better. It's just, well, they're marginally not as bad. They have marginally not been as bad as they might have been. And the other day, yes?
I apologize for interrupting, but
No, please.
I struggle in my own self with the concept of collateral damage that you referred to. And I hear you struggle with collateral damage. And I am in the common argument in our group is, well, go after the low-hanging fruit. If you get an inch, take it. Don't try to get a foot. Yes, okay, so we don't get everybody off retroactivity, but we got a couple people off, so we should be happy. And I keep asking myself, well, what about the person who's being harmed? What about the person whose family who are being harmed? What about the person whose family who have been attacked? In New Hampshire, we've had persons killed on the registry. I'm not talking hurt, I'm talking dead. Okay? That's collateral damage that I don't think is acceptable.
It's not. It's not.
Arguing that we got something. Arguing we got a little bit. Why is a bite okay when it's ethically and morally wrong?
It's not. It is ethically and morally wrong. It's not okay. The problem is, and it's a problem, it's not, I don't have a solution, I have a problem. And the problem is that we live in the real world. And in the real world, there's only, unfortunately, so much we can do. It's why Skindle's right, that he has, in fact, helped make the law not as much awful as he can. Look, what is the goal? The goal is to do away with this whole system. The goal is to treat people like individuals. The goal is to respect the fact that most of the people, the vast majority of the people who are convicted of these crimes, and in fact of all crimes, are not the evil monsters that they're made out to be. That's the reality. That's what I want to convince people of. That's what we need to convince the legislatures of. That's what we need to convince the great public of.
A few specific facts I want to lay out to you. I want to know if
Can you speak up, please?
Oh, sure. There are a few specific facts I'd like to lay out to you, and I want to know if these facts correlate to this big explanation that you just gave about all this. So in 2006, a person is convicted of a sexual offense in New Jersey, and they're classified as Tier 1, and they are not on any registry, and they only report one time a year. That person moves to Ohio in 2008, in August of 2008, and Michael Lyons, the Attorney General, and they're suddenly made Tier 2, and now they have to report every 6 months. And they go to a lawyer, and they find out about this big class action lawsuit, which is probably what you were talking about. And they get signed into that. And then the result comes back from they shouldn't have gone to a lawyer in the first place. They should have just taken to tier 2, and they would have been fine, because now we're on, now they got this community notification, and, you know, it's just, the whole thing is just much worse. How did that happen?
It happens because they hate your families. They hate you and they hate your families. I mean, that's the you know, I mean, that's the answer. And yeah, I mean, it's a function of the law. There's a mechanism to challenge out-of-state reclassifications, whether it applies in that case or not. It's beyond my knowledge of how it actually works, whether it applies in that case, whether it would apply in that case or not. I can't tell you. I don't know. It's really out. I just know there is a mechanism out there. I don't know.
Do you know anybody that does that?
Any lawyer could learn about how it works and whether it had a chance of applying. I don't know anybody who's doing much of that work, but there are, unfortunately, you know, here's a rule. Stalin, because it's always useful to remember Joseph Stalin these times, and Joseph Stalin said, or is said to have said, it's not 100% clear that he actually did, but he's said to have said, the death of one person is a tragedy, the death of 1 million is a statistic. That's the value of stories, and stories are used against us all the time. Megan's Law was named after Megan Kanka, right? She was a child. She was a victim. That generates a lot of sympathy. The Adam Walsh Act was named after another child. We just in Ohio enacted constitutional amendments. Something like 87% of the voters voted for the constitutional amendment back in November of Marsy's Law, which says which says, in short, victims have in the Ohio Constitution every right that criminal defendants have. And by the way, we know they're victims because they said they are. Doesn't matter whether it's true. In sex offense cases in Ohio, in all documents that are made public, the alleged victim is to be identified only by initials. If it turns out that the case is reversed because it didn't happen, because the alleged victim, because the person is wholly innocent, the alleged victim is in fact, who's the victim in the case? The person who was charged with the crime that he didn't commit, or she didn't commit. That person's name is going to be public, but the alleged victim's name, the lying victim's name, will remain a secret in the public record. That's Ohio law.
87% of your voters. Need a better education.
Yes, ma'am.
Why has no one taken on the issue of the lying victim?
Uh,
Why is there no retribution? Because there's so much collateral damage from an accusation. And once it's made, everyone believes it. Well,
yes.
something must have happened.
Yes, of course. Anybody who's not convicted, they got off on a technicality. Of course you were guilty. There is this legal presumption of innocence, but there is a real-world presumption of guilt. If you're charged with a crime, any crime, by the way, if you're charged with a crime, you must have done it, or you must have done something terrible, because we don't make those kinds of mistakes. If a mistake was made, it was some legal technicality or some rogue juror or some judge who did some stupid-ass thing. And really, if you were charged with a crime, you're evil, and you probably ought to get a sentence of at least life with cancer. That's the world we live in. And we'll go here first.
Can you speak to where we are now, currently in the state of Ohio, and in what areas you feel, or your committee, your coalition feels that we have the best possibility of winning?
Well, unfortunately, the coalition has dissolved, which is kind of where which is where I was going with this, but I've been thinking about it a lot lately, and I know I'm not the only one who has been. And one of the things, there are actually some positive things that are happening in this state. They aren't helping here, but there are some positive things that are happening. And David and maybe some other people over the last couple of days have talked about, a kind of recognition that mass incarceration is a problem, even though they think the only people that are being mass incarcerated are low-level drug offenders who are altogether nonviolent, and that's just not true. But it's not even close to true. But people are paying attention to some of that. There is some beginning of awareness, and some of it is filtering down to Ohio, that when people get out of prison, it would be better if they weren't forced to be homeless and jobless. If they could actually manage to not be a drain on society. There is some beginning thought in that direction. And one of the things that has happened that that the legislature has actually done is increase the opportunities to have convictions expunged, so that when you apply for a job, you can honestly say, if your conviction for a crime has been expunged or sealed, I have not been convicted. Because you've been not only unconvicted, but the record is sealed. There are exceptions to that. There are times when you can't say that, but in general, that's been a great thing. There is an absolute exception. Sex offenses cannot be sealed. They cannot be expunged in this state. That's the statute. No matter what, can't be done. Within the range, and we talked about this briefly the other day, within the range of things that have actually some prospect of becoming law, becoming better in the next couple of years, is allowing expungements for some category of sex. It doesn't mean it'd be automatic, but at least allowing some break for some people, juveniles, who can make some argument that they're never and expungement is never required. It's always in this state. It's always at the discretion of the judge you're in front of. But it's an opportunity, and that's a baby step. It's a baby step. I know that, and you know that, and the goal is to eliminate this whole thing, but we're not going to do that Thursday. It's just not going to go away next week. And I can't do it as a lawyer. I don't have a challenge that's going to shut this whole thing down. And I'm not sure what the next good, broad-based legal challenge in Ohio is. I'm looking for it. I'd like to stumble across it. I'm not sure what it is. But in the legislature, which is ultimately where this thing has to be resolved, in the state legislatures, and that's where you can, in fact, maybe see some room for small steps. And if you get the small step, then here's what happens. You notice that, oh, wait, now we've expunged this guy's conviction. We've sealed it. He can get a job. He can live somewhere. At one point when we were arguing residency restrictions, we tried to make the argument in court in Cincinnati that, and we actually drew a map and it didn't quite work, but to show that the only place in Cincinnati where sex offenders could live under state law, and this was when the first residency restriction laws came in, the only place in Cincinnati where a sex offender could live was downtown where the tourists are. And we thought, this is good. I mean, that's the one place they don't want these folks hanging out. It didn't quite work, but we really thought we had something there for a minute, and because it's the story, and what I'd love to find is the story backed by data is what you need. The story to get attention, the story to get people to care, to want to do the right thing. We have the data, for God's sake. We know all that. We know the recidivism rates. We know that putting people on registries gets folks killed. We know that it leaves them out on the street. We know that we're breaking up families. We're destroying communities. We know all that. We know what you're suffering. We have the data.
So what would it take to decide to the point where
I want to.
Brown versus the Board of Education, you get lots of small cases of people dying, suffering, being homeless, their children starving, and put them all together. What would it take for society to care about it like they did with Brown versus the Board of Education?
Well, that one, see, we're not going to win this fight in the courts, not in the long run. I'm not going to win this fight. It's going to be won in the state legislatures. It's going to be won in referenda in the states. It's going to be won when we find some kid that we can draft a law named after. Some kid who's a victim of the system that's out there that's hurting. I want, Sally's Law. I don't know who Sally is, but find me Sally who's 7 years old and really cute, and then we go public, but and get on TV and do the, I don't know. Yes.
Since Bodyke, does the state of Ohio run 2 registries for people after, so they're actually running 2 registries? How do they like doing that?
They don't particularly, but they're settled into it by now. Actually, when they enacted the Adam Walsh Act, they repealed Megan's Law. And when I was arguing the Adam Walsh Act in the Ohio Supreme Court and saying, you can't do this, you can't retroactively, they said, well, what are we going to do with these people? The old law doesn't exist anymore. We can't have them registering under the old law because it doesn't exist. We can't give them back. And I said, sure you can, because otherwise, they were going to deny it. They were going to flat out say, well, no, since they have to register somewhere, we certainly can't just let them off the hook here. But the truth is, all those Megan Law registrars are registering under a law that does not exist in Ohio. And one of these, that's a lawsuit we've actually been trying to figure out how to put together for years, not successfully, but that's been a goal. If I could ever figure out how to make that one fly, I'd love to do it, but I haven't been able to figure out exactly how to do it and how to sell it. And I'm out of time, yes? 30 seconds. Yes, go ahead.
Well, he's actually from Indiana, and he got charged. It was all over the national news. His parents actually spoke here 2 years ago. He was 18 or 19, and a girl lied and said they met on the internet.
He's not the person I want.
Why?
Because he's the one who people think, I don't care about the fact that everybody knows he didn't do it, that it was consensual, that it's not real. He was charged with a crime. That makes him a monster. Nobody undoes the guilt. The assumption is if you were charged, you're bad. If you were charged, you're guilty, and anything that happens afterwards doesn't count. It's
the media that has made the nightmare out of this, stirring everybody up into all this panic.
right.
When the facts are so clear that their view of this population is so distorted, because the message that has to get out there is this could be you. It is your family that's next. It is your one that is next. It's your son, it's your daughter that's going to be a victim of one side of this or the other. That's the message that has to get out, and he was not interested.
Jeff, are you saying you're looking for a child whose life has been ruined because their family member is on the registry?
Yes. and find some way to I mean, that's not a legal help. I mean, those legal arguments don't go anywhere. That's the person that you want to have a law named after. You know? Or better still, a child who is somehow the victim, but not really the victim, and that, yeah. Somebody who just oozes, who nobody can say a bad word about.